I'm starting off with what are called hot topics. So everything I say is effectively hot off the press. Having said that, it's largely a little bit lukewarm, but it's still off the press nonetheless. So first of all, just starting with a couple of preliminary things concerning some recent county court cases, which are obviously not binding, but deal with, guess what, disrepair in one guise or another. But essentially, county court decisions coming down if you are found liable for breach of the implied covenant under Section 9, capital A of the Landlord and Tenant Act of 1985, that is, that the premises are unfit for habitation, then damages are going to be quite high. And they are going to be significantly higher than for breach simply of Section 11, the structure and exterior of the dwelling house. Recent county court cases have seen damages awards for breach of Section 9A in the region of 90 to 100% diminution of the rent. That works out at an awful lot, and an awful lot more than county courts are awarding for breach of Section 11. But this should come as no surprise to seasoned disrepair watchers, and I imagine you all are, whether you like it or not, in one guise or another, because in 2004, you will remember the case of English Churches Housing Group and Mr. Avram Shine for a limited period, where those premises were, I think, described as being virtually uninhabitable. Section 11 damages were 75% diminution. So if the premises are unfit as a whole for habitation, resulting in a breach of covenant under Section 9, capital A, you are going to be looking down the barrel at 75 to 100%. Plus, of course, any special damages or any personal injury claim that may also be brought in addition. Swiftly on to another matter, which is quite a hot topic, because if you are a social landlord facing a claim for disrepair, and this in particular applies to local authorities, but everybody else just bear with me and listen up for a moment, you may wish to bring a counterclaim for the tenant's breach of covenant. So, for example, significant arrears of rent, for tenant damage to the premises, which the landlord is being obliged to make good. In those situations, you are fine because you are claiming or counterclaiming for a breach of covenant. With the rent arrears, check the age of those arrears. There have been quite a few cases where there have former tenancy arrears, which have been added to the total indebtedness of the current tenant, which are over 6 years old. It is, of course, for the tenant in the reply and defence to counterclaim to plead limitation in bar, but just be careful as to how old those rent arrears in fact are. In regards tenant damage, the one thing I would say is if you are going to bring a counterclaim for that, please quantify it by reference to a works order or an invoice, and not simply a works order for everything and then leave the court and everybody else to work out which of those items was allegedly caused by the tenant or not. So you will need a separate and distinct works order or invoice because you are effectively claiming a liquidated sum. The thing that has caused quite a bit of concern relates to local authorities in particular, because you may have a tenant bringing a claim for disrepair, which may be worth £1,500, but you may have council tax arrears of £3,500. So you think to yourself, right, well, we've got those arrears, we'll show them the council tax account and we'll counterclaim for it. Be very careful, because Section 16 of the County Courts Act provides that it is not recoverable in the county court if it's otherwise recoverable by statute summarily. And under the council tax legislation and the regulations, they provide for a self-contained scheme for enforcement of council tax arrears. So how do you go about doing it? Well, you wouldn't counterclaim, because then there'll be a massive argument about whether or not you are in fact in breach of Section 16 of the County Courts Act, because you were trying to enforce, by way of a claim, in this case a counterclaim, arrears of council tax. What you will need as a local authority is first to get your liability order from the magistrate's court. That crystallises the debt. And it effectively is a judgment debt. You can't enforce it in the county court. You go back to the magistrates to make them bankrupt, get an attachment of earnings order, or sell their goods, or whatever it may be. So, if you have liability orders for arrears of council tax, what do you do in your defence to the claim for disrepair? And the answer is not counterclaim. The answer is to plead a set-off, because you're entitled to do that. You have a crystallised debt as a judgment sum. All right, it's been summarily determined in the magistrate's court, but it is still a debt due and owing to the local authority, pleaded as a set-off and not a counterclaim. And the best port of call for how one deals with a counterclaim, a set-off, whether it's legal or equitable, is the case of Ferns and Anglo-Dutch paint. And in case anybody's really interested and is taking notes, that is 2010, EWHC 2366 in the Chancery Division. Very good summary as to what you can set off, how you go about it, and how that is determined by the court. So by seeking a set-off, you're not actually enforcing the council tax debt in breach of the regulations and the County Courts Act. You are just deducting a crystallised judgment sum from any damages the tenant may be awarded in due course. And as is the case with any pleading, as my dear old late, sadly departed friend, Mr. Brian Maguire, Queen's Counsel, as he then was, would say what you mean and mean what you say. Make it crystal clear in your defence that you are pleading a set-off, and you will seek to set off that judgment sum from any damages as may be awarded to the tenant. That analysis, set off as opposed to counterclaim, has been confirmed by a couple of cases, I think in the Birmingham County Court, but it is likely to hold water should it ever be appealed. The Leasehold and Freehold Reform Act essentially prevents the creation of long leasehold interests for houses as opposed to flats. Now that is long overdue. Quite why developers were giving long leaseholds of semi-detached or detached houses on new developments is utterly beyond me. The acquisition of freehold and extension of long leasehold is becoming easier as a result, and there is going to now be a reduction in rent, in ground rents on request by the tenant to 1 peppercorn. Now, being an old-fashioned kind of landlord and tenant guy, I love that. The Renters Reform Bill, among other things, the abolition of no-fault Section 21 evictions, has fallen by the wayside and will need to be reintroduced. But I think it will come back in, and I think we will see the end of Section 21. The other thing which may have been of significant concern as well to the social housing sphere is that the regulations to implement Awaab's law have not yet been put in place. You will probably be aware that a consultation came out. I'm not aware that there was a consultation response prior to the dissolution of Parliament. We will have to wait and see. But those regulations effectively are going to mean that social landlords are going to have a very short timescale within which to remedy defects, principally defects falling within Section 9A of the Landlord and Tenant Act of 1985 and the explanatory section in Section 10 as to the type of defects that fall thereunder. It's been quite a whistle-stop tour of hot topics, but those are effectively the things that are at least warm off the press for your delectation and delight.